Welcome to Case Series. Don't forget to like, share, and subscribe for more courtroom drama.
Mr. Lewis, you have Crystal Vogan. This is sentencing. Good morning. This is Mr. Hoffpower's sentencing. I didn't see you over there, Mr. Hoffpower.
Buckle up, because today's courtroom chaos takes us deep into Texas, and then all the way to Florida. We're starting with a woman who somehow managed to secure a sweet plea deal, despite having nearly 4 pages of criminal history. 4 pages. But before the judge can even blink, this defendant's mouth nearly lands her in jail on the spot. This isn't just about theft, it's about arrogance, attitude, and the one judge who refuses to let either slide. And after this wild sentencing meltdown, we'll shift gears to a Florida courtroom, where a self-represented defendant tries to talk his way out of a revoked bond. 2 states, 2 disasters, and one wild ride through justice that proves some people just don't know when to stop talking.
Good morning. Good morning. Are you Crystal Vogan? And Ms. Vogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes.
And any additions or corrections or...
There's a lot of history, we understand, but discussed it with counsel also about the restitution.
Speak up, I'm
I
sorry.
just want to make sure the court knows the restitution, most of the main issue we're looking at, get some of that money back.
I've got 1, 2, 3 and a quarter pages of criminal history. Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed. At least 4 or 5 misdemeanors that weren't dismissed.
You can hear the tension rising as the judge flips through the defendant's record. And it's not just a few charges. We're talking a book-length criminal history, thefts, forgeries, and multiple felonies. When a judge uses words like 2, 3, and a quarter pages of criminal history, you already know mercy is off the table. What's wild here is the defense seems focused on restitution, as if paying back the money will erase a decade of crimes. Judges don't just look at the numbers, they look at patterns, and Crystal's pattern screams, repeat offender.
I understand the restitution, and y'all know my position on that already this morning, but there's... I mean, she's on probation right now in Sutton County, correct?
Yes.
Right. So do they know about this case? And what has happened over there, if anything?
I'm still continuing on my deferred. Because I'm actually supposed to start nursing.
I can't understand you.
I'm supposed to start nursing school.
When?
I was actually supposed to start in September, but I had to wait to see.
Are you really going to be able to go to nursing
Yes, I
school
am.
with this type of
Yes,
criminal
ma'am.
history?
This is deferred, yes, ma'am. Because I haven't been convicted of it. I'm a CNA now.
Another issue that I see on here also is the restitution, because it shows $9,400, but then it also, that was from inside the bank, and then it shows $500 from an ATM and $100 from a cash app, totaling $10,000, not $9,400. Is that correct?
And that would have been added on, I don't think that's a bank fee, I believe. I don't think that.
Well, it says $500 was withdrawn from an ATM outside the bank. You know better than anybody.
I only went into it. I didn't have no access to the card.
Okay. So possibly the other person that was involved did that?
Only thing we knew about
That
was
was
the 9,400 that within the bank?
I wasn't aware of it, Your Honor, when we did it, when I got the PSIs, when I was notified, I was in the cash wrap. But if it was a withdrawal, then that would be her responsibility joint and separately, so
Right, it says, so
that's a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, 94 from inside the bank, 500 from an ATM, and 100 from a Cash App transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of the?
I don't have the other status of another person, Your Honor. That's just one that's the charge. I'm not coaching on there. But
Okay.
she's responsible.
Yeah. So I mean, if there was another person, and you didn't give that information, then that's okay. Apparently the cops didn't either. So
She went in the bank. She was one call. Size, whether or not she had a conversation. The backside, not to my knowledge.
This next part is almost surreal. Crystal claims she's about to start nursing school, while currently on probation for theft and fraud. That's the kind of statement that makes any judge pause mid-sentence. The irony here is staggering. Someone with a record of stealing identities and cash wants to enter a profession built on trust and care. It's one of those courtroom moments where you can feel the disbelief in the air. And when the judge bluntly asks if nursing school is even possible with that criminal history, you can almost hear the entire room freeze.
and hold on. So the probation's in Sutton County. Have they been transferred to Harris County? So you're going in person in Harris County.
Yes, ma'am.
Okay, and so it's the state's position to go forward with the agreement?
I understand the court's concern, and the state has the same. Like I said, our initial deal was to get some of the money back on our victim. However, we
So,
understand.
all right, so here's what I'm going to do, Ms. Bogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence. I just don't know. I just can't believe I'm even considering doing this, honestly. I'm not. I can't. There's no way. I mean, it has to be straight probation, and I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of thing. So
I don't.
you do.
No, I don't. No, I don't.
Okay. How many?
Notice how Crystal tries to shift blame when the judge questions her about the stolen funds. She claims she didn't have access to the ATM or the Cash App. But the judge quickly reminds her that working together means shared responsibility. Whether she withdrew the money or her partner did, it doesn't matter. Under the law, accomplices in a joint theft are equally guilty. This is a classic move from defendants with long records. Deflect, deny, and downplay. But when you're in front of a judge who's read every word of your PSI, there's no hiding behind excuses.
Okay, you have lots of them that were at the same time for different offenses.
I was never convicted, never charged.
Yeah, you did probations for them. Forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail, so that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation, so that's 2 in Ohio. March of 2014, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all of that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm going to run out of fingers. March, another one, a theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 5 continuous smuggling of persons for pecuniary benefit, and that's the 10-year probation that you're on in 5 different cases. That's not correct.
No. Okay.
So how many cases are you on probation for in Sutton County?
It all ran together.
I understand it all. It doesn't run, but that's not how it works.
Yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. You're at, ma'am,
What?
this is not going to help.
It don't matter. My life's on anyway.
And here comes the turning point. The judge openly admits, I can't believe I'm even considering doing this. That's your warning shot. Judges rarely say that unless they're about to throw the book. When she calls out the 14 prior felonies, the case shifts from probation talk to damage control. Deferred adjudication? Gone. The judge refuses to let Crystal have a clean slate after probation. It's a pivotal decision because it not only affects this case, but also shuts the door on her ever clearing her record again. A moment of judicial backbone that defines this courtroom.
Come on, hold on, get her, don't let her go. Come back.
What?
Everybody heard it.
You're bullshit.
Come back.
You're a lawyer.
I told my lawyer he was bullshit. I didn't say that.
You don't talk like that to anybody in this case because he didn't do this either, you did.
He got me the plea.
He did get you he did a great job because of your attitude and because of your criminal, because of your,
I gotta go to work. So I'm gonna lose my job and everything too.
Well, maybe you shouldn't cuss at your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at? Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're going to make it worse. You're just going to make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. All right, I'm going to set your bond at $25,000. Go back with the bailiff.
Call Mr. McCoy's case.
Mr. McCoy?
Our conversations are concluded.
McCoy is here today. I've revoked his release based on his new charge. He held without bond on that.
Now, watch the collapse in real time. The judge lists off charge after charge, financial crimes, drug possession, theft, and then 5 smuggling of persons convictions. That's when you realize this isn't just another petty theft case. This woman has a career in crime. But instead of staying calm and quiet, Crystal interrupts and argues. That's the final straw. Judges can forgive bad decisions, but they rarely forgive disrespect. What began as a plea hearing ends as a bond hearing, and Crystal manages to talk herself straight into a $25,000 bond and a trip back to jail.
And Mr. McCoy, you understand that you're representing yourself. I have found you competent to represent yourself. At any point in time, these procedures, you can ask an attorney if he appointed to represent you.
Yes, sir.
Do you still wish to represent yourself?
Yes, sir.
Okay. All right. Looks like there's been some, there's been a DCA case filed. I don't know if it's based on the discovery request or not. I don't know. All right. Yes, that's what it looks like. All right. Anything else today?
No, Your Honor.
All right. Yes, sir.
Yes, sir. Well, first, I would just like to request that my bond reinstated, sir.
Motion denied.
And reason being, sir, can I please have an explanation why?
Charge, you pled to that charge.
And the only reason, sir, regardless of the facts, the only reason I accepted the case, that charge is because they said they was only going to give me a fine. But the person that actually, was in the fight, they came there and they seen that I was breaking up the fight.
Mr. McCoy, I've already made my decision when you entered.
I understand that, Mr. Clark. I'm just stating this for the record.
You've set the motion that you were breaking up a fight and that you didn't cause a fight and you weren't involved in the fight, that you were the peacemaker, but however you did enter a plea, and that's all part of the record. I understand that, but I am going to deny your motion to reinstate the bond.
All right, Mr. Clark. Can we discuss my case? I was here for a court date on my case.
Well, you've already filed a notice of appeal on the second request for discovery, so I don't know what else there is to discuss today.
Well, and that I was wanting to discuss, sir, is the fact that, my subpoenas and everything never got responded to. People about my the videos of my evidence, sir.
Well, if they've been served with subpoenas and they haven't responded, you need to do a motion for show cause.
Motion to show cause.
Yes, sir.
Okay. What about I just want to know your opinion, sir, since you're the judge.
I can't give you my opinion.
No. Based on the proceedings, sir. I was discussing with Mr. Frank Sullivan. It's not looking for help. All the thing I'm asking, sir, is why am I being denied my evidence?
I don't know, sir.
Okay, if Bay County officers was the primary officer, sir, in my case.